Well, good afternoon. I have the pleasure to chair the next session. We've obviously made sure that we aired the room properly, and we had some jokes over lunch saying that there's probably a European regulation that allows more space to chicken than to people in this room. So we're well aware that the interest in the session and the sessions before has obviously been great, and there is only a limited level of oxygen in the room, and we therefore want to make sure that we stay at least in this session to the potential time limits, and if I manage to wield the whip properly, we probably manage to catch up a little bit on time. I'll just briefly introduce myself. My name is Andreas Gunst. I'm a partner at DLA Piper, spending my time between Vienna and London on a variety of energy matters, including some arbitration, and I've got the great pleasure to share the next session around that topic. I'll introduce the first speaker, Dr. Pitkowitz. He's the second. Okay, good. Then we do it the other way around. I'm very sorry. Ladies first. I should have been more gentlemanlike. Okay, so in fact, the very first speaker will be Rozeta Karova. She is with the energy community, a very experienced energy lawyer. And Rozeta, floor over to you.
Thank you very much. Thank you very much for introducing me with these kind words. I am indeed with the Energy Community Secretariat, and the topic that I will speak to you today about is very close to my heart, so it's enforcement, and to every lawyer working for a community based on the rule of law, of course, strong enforcement, it's the key for success, so it's the key for ensuring that the objectives of the energy community are achieved, but also that the efficient protection of investors' rights is ensured, and the protection of the values on which the energy community is based is taken care of. So, as you saw after the title, my presentation will be structured in the following manner. I will first talk a bit about the enforcement system as we have it today. So what kind of dispute settlement rules we have enforced today in the energy community, and how do we apply them? What is the problem? What are the benefits of having this type of dispute settlement at all? And how does it work in practice? So to share a bit of the experience that we have through the years of growing up, as Professor Schmidt von Sydow mentioned this morning, and also in which direction we are discussing that the reform should go. In this manner, I will not that much talk about the proposed solutions. That will be left to the second speaker of the session, but I hope that talking to you about the enforcement record to date, and talking to you about what kind of dispute settlement rules are we applying in the energy community, I would like to discuss with you and to pose the question also to you whether you see it fit to ensure the achievement of the objectives of the energy community, about which we spoke in the morning sessions, and whether you also would see as lawyers, and I'm very happy to see this large number of lawyers present here today, whether you would agree that the energy community, as it's growing and as it's getting more and more strong, whether this type of dispute settlement mechanism does not need any reform. Very briefly, many of you, and those ones especially coming from the contracting parties, are aware about the dispute settlement rules that we have, but these couple of slides are just very brief overview for those of you that do not know the details. So there is, similarly to the EU enforcement system, the preliminary procedure is carried out by the Secretariat before a case is brought to the attention of the Ministerial Council. So it was mentioned this morning, we do not have a court in the energy community, but whenever there is an infringement action, dispute settlement procedure held, the case eventually would go to the Ministerial Council for a decision. As you would see, the procedure could be initiated by the Secretariat on its own motion, but also by a complaint by any private body. And here I underline that there is a broad standing, so everybody could approach the Energy Community Secretariat and could complain against a contracting party. After assessment of the case, then it's up to the Secretariat to decide whether it will send an opening letter, which basically corresponds to the letter of formal notice that the European Commission sends to the EU member states, and depending on the answer from the contracting party in question, to decide whether it will address a reasoned opinion to it. During the preliminary procedure, basically the contracting parties have a lot of opportunities to be heard, a lot of opportunities to discuss with the Secretariat, a lot of bilateral negotiations are going on, and basically most of the cases, as I will show you later on, are finalized in this preliminary procedure, during this preliminary procedure, and not many of them, and in fact only 2 cases so far, have been brought to the attention of the Ministerial Council. So this is the second step of the enforcement procedure. It is the procedure before the Ministerial Council, and you would see that the Ministerial Council brings a legally binding decision, which is basically a yes-no decision. So it either says that there is an existence of a breach. The Ministerial Council can say that the contracting party has done a serious and persistent breach to the obligations from the treaty. It may impose sanctions, which you will see has never happened so far, or it may dismiss a complaint, which has also not happened so far. The important step in this in this procedure before the Ministerial Council is the opinion of the Advisory Committee. And that's the only legal reasoning that we have throughout the procedure, assessing the legal arguments put forward by the Secretariat, which have opened an infringement procedure against the country. So far, in the 2 cases before the Ministerial Council, it has largely upheld the arguments of the Advisory Committee, but there is no discussion on the legal arguments. There is no agreement. They are not binding. The opinion of the Advisory Committee is not binding for the Ministerial Council, but the Ministerial Council itself just says, yes, there was a breach based on the assessment of the Secretariat and the Advisory Committee opinion. So now, knowing how the Energy Community Dispute Settlement Mechanism works, here I have summarized a bit for you what are the main characteristics of this system. So, as you could see, this is a political mechanism which does not lead to a judicial decision if you see that the Ministerial Council is the one to has the final say. It also considers cases only infringement against the contracting party. So there are no direct actions and there is no right of appeal. This would sound strange for many lawyers because we have legally binding decisions from the institutions of the energy community, and besides the Ministerial Council, also the Regulatory Board and the Permanent High-Level Group could, if empowered to do so, take a legally binding decision, but there is no right of appeal. Also, there are no preliminary references, so like to the Court of Justice, because obviously we do not have a court. So this means that the national courts are basically not involved in the full process, and there is no possibility for any judicial dialogue because there is no court giving a final decision. Also, being a system of disputes initiated only against contracting parties, it means that there are no disputes heard between private parties, and also there are no investor-state disputes addressed with this dispute settlement mechanism. So basically, the only right of protection to the investors given through this system is the mere right to complain to the Secretariat, which happens very often, to approach the Secretariat and to complain against the contracting party, saying that the contracting party X or Y has not implemented on time or has wrongly implemented legally binding energy community legislation. So obviously there are limits to this type of dispute settlement system, and as it was also acknowledged in the morning, in the first years of existence of the energy community, there was not even a need to have any kind of dispute settlement mechanism from day one, because it would not be applied in practice before the deadlines and the obligations, the deadlines for obligations of the contracting parties expire, or before there is any kind of starting up of the process of reforms in the contracting parties, before the ownership of the energy community is not taken by the contracting parties and the participants to the market. So the political nature is obviously a limitation to any dispute settlement in a community based on the rule of law. It has an ad hoc character, so the Ministerial Council meets once a year, and that is the moment when there are many other topics, as you may guess, on the agenda of this political body to decide about the future of the energy community, to decide about daily things. So the dispute settlement is only one of the topics of the agenda. So also when the Secretariat considers whether a case should be brought to a Ministerial Council, have also to take into consideration whether not the full agenda of the Ministerial Council would be blocked by deciding on a couple of cases. There is no legal assessment, so as I said, the Ministerial Council takes a yes-no decision, so also the incentive for the Secretariat to bring a case before the Ministerial Council is obviously limited. And also, another thing, if the decision makers, which are the ministers in charge of our energy, are the ones who are also responsible as representing a country that is a subject to a dispute, you may guess the outcome of such a decision. Imagine a case that I will mention a bit later on, again initiated against several contracting parties. If 5 or 6 contracting parties are at the list to be infringed by the Ministerial Council, and all these 6 ministers have to vote for any of their peers, would you expect any reasonable or any kind of legally binding and efficient decision? So, of course, the other limit is we don't have a court, so the Ministerial Council is the only body with which we are left to plead our cases in front. And also there are no effective, dissuasive and adequate sanctions. The Ministerial Council can indeed impose a sanction against the contracting party if it infringes the energy community law, but these sanctions are basically a suspension of voting rights, exclusion from the meetings, or from some of the mechanisms under the treaty. So we can interpret what does this mean in practice and what kind of sanctions can be imposed against the contracting parties, but so far in these 10 years of existence of the energy community we did not have a chance to hear about any of them, because even though at the last Ministerial Council this body had a chance to impose a sanction against Bosnia and Herzegovina, this did not happen. So I would like to sum up about the existing energy community enforcement system is that it's one of the weakest points of the energy community. So we have heard, especially during the last couple of years, a lot of calls for its improvement, be it by the energy community institutions themselves or also by the European institutions. So very briefly, if we are living with this dispute settlement mechanism, then what is the other protection of the energy community values and legal rules? What other means do, for instance, the investors have? I will not go into details, but the options are clearly limited. So they can go to the national courts, which obviously do not also know very much about the existence of the energy community law, and they certainly do not apply it in practice, even though one could claim that the direct applicability and the state liability are also concepts part of the energy community law. And also international arbitration, maybe we will hear then later on more about this. But for the moment it has not been considered suitable also for domestic undertakings or for small investors. They would rather refrain from bringing the case to arbitration. What is the practice so far? So I think this would be one of the most interesting slides for you to hear what type of cases the energy community has had so far and what kind of issues are we discussing. There have been many cases initiated by the Secretariat against contracting parties for lack of transposition of energy community law, but also a number of them have been dealt with non-implementation or not incorrect implementation of the energy community law. It's interesting to see that even though it's a sector-specific community, and of course energy is at the core of our business here, the Secretariat has initiated cases going beyond the energy area, and we have looked into the other areas of law that are part of the energy community acquis. This morning, you may remember the slide that the Director Kopac has presented to you, and even though limited, still we have binding, legally binding legislation in different areas. So the Secretariat has so far initiated 3 cases for lack of state aid legislation in the contracting parties, several cases for not implementation of the Sulfur in Fuel Directive in the environmental field. We have also opened several infringement actions against contracting parties for not implementation of energy efficiency legislation or for not submission of renewable section plans. So, as you may see, the areas of law are going beyond energy, and that makes also the energy community law and the dispute settlement system more relevant for the countries. There have also been cases initiated against a single country, but also few of them are addressed against more than one contracting parties. So, for instance, here I refer to a case that we have opened against 6 contracting parties for lack of common coordinated congestion management method. This case has never arrived to the Ministerial Council, and currently we have also closed the case initiated against several contracting parties. But through the years, there have been maybe plenty of possibilities to go to the Ministerial Council with this case because the breach was quite obvious. We did not do that, and maybe you would remember a few of the issues that I have mentioned related to the limitations of the dispute settlement system and limitations of a Ministerial Council deciding on such a case, and you would guess why this case did not manage to arrive to the Ministerial Council. But we also have other very interesting cases that are inspiring for lawyers not only from the contracting parties, but also lawyers from the EU member states, lawyers working in the Commission, lawyers pleading in front of the European Court of Justice. For instance, the European Commission and the Court of Justice never had a case about cost reflectivity of tariffs. It is not that relevant for the EU member states, maybe because the distribution tariffs are not that much discussed as they are in the contracting parties of the energy community. But this is a very interesting concept that was developed by the Secretariat in its opening letters against, we had an open infringement that is now closed, and you can see it on the website, against Montenegro. But we also have been approached by several other investors from other contracting parties related to the same issue. So obviously the cost reflectivity concept that has never been discussed by the European institution, it is a legal concept, and it was quite in the focus in the energy community. The local content requirement is a case that was initiated against Ukraine. So this is also a case that does not have a precedence in the EU. And also we are discussing cases for lack of unbundling. The last one and the only one that made its way to the Ministerial Council is the case against Serbia for lack of ownership, for lack of unbundling and fulfilling the obligations under the second package even, where the Ministerial Council found that Serbia breached its obligations under the treaty due to lack of unbundling. And that's it. There was no further discussion, there was no reasoning behind it, and there was no sanction, as you could guess. But as I said, even without making it to the Ministerial Council, so far we have achieved positive results in the preliminary procedure carried on by the Secretariat. Because as the Commission has also quite discretion when it negotiates its case during the preliminary procedure with the Member States, we also do the same, the Secretariat with the contracting parties, because at the end of the day, the aim of the dispute settlement is not to have a decision by the Ministerial Council or to have a fine against the contracting parties. The objective behind it is to achieve compliance. The objective behind this is that the contracting party in question complies with the obligations that it has legally undertaken to bring into compliance, whether it's to adopt a legislation, to adopt a primary, secondary legislation, to repair a behavior by some of its market operators, whether it's a TSO, whether it's some of its institutions such as the regulator, and so on. So the idea is to achieve compliance and to go forward with the reforms. So we have also heard that this has been the case, and these positive results have been achieved due to basically the persuasiveness of the legal arguments put forward by the Secretariat in its opening letters and in its reasoned opinions when the case has made up to that stage. The Secretariat has not referred only to, has not based its opening letters only on the pure provisions of the energy legislation, but also it has relied on the free movement provisions. We have only the free movement of goods in the treaty, but we have used it quite extensively in our infringement actions. We have relied on competition provisions. We have also relied on general legal principles. The principle of non-discrimination, the principle of proportionality, legal certainty have been quite often invoked in our cases. And also we have backed our arguments with reliance on the European Court of Justice case law. Of course, it is an external judicial body, but when we do not have one inside, and we have a reference in the treaty that we will rely on our cases with the European Court of Justice case law, we have done that extensively. And that basically leads also to the countries and to the operators to comply and to bring to an end the infringement. Of course, then also the limits are that there are sometimes politically sensitive cases that it's difficult to make up to the Ministerial Council, but also, as I said, the possibility that the Ministerial Council have never used to impose sanctions to the contracting parties in question. So what is the future? It's obvious that if we are a community based on the rule of law, if we have a legally binding treaty and legally binding legislation and obligations, this dispute settlement system as it stands now, it's not fit for delivering the results and the expectations. It has been mentioned that we are discussing the high-level reflection group proposals. There was an analytical paper drafted by the Secretariat and the European Commission, a public consultation. So here are some of the possible ways. We are discussing establishment of a judicial body, and you would all, I hope, agree that it would, of course, introduce judicial protection for the countries to which a decision has been adopted by the institutions of the energy community. It will overcome possible deadlocks in the Ministerial Council when a case against several contracting parties have been brought in front of it. It will allow also interpretation of the treaty and applying EU constitutional principles by a judicial body of the energy community. But it will also contribute to development of the EU energy law, because as you heard, we are looking into cases and issues that are not only region-specific, but also that have never been addressed so far by the European institutions. And of course, we would like to see a revision of the system of sanctions, including financial penalties, because that would, in our view, increase compliance with the energy community law and, of course, would ensure effective implementation. Thank you very much for the attention. I hope I was brief enough. I'm open for questions.
Yeah. As you've seen, I struggled to cut it short because it was, in fact, so interesting and so difficult to actually really give the succinct account that we just received in as few minutes as 15. So I hope you apologize that. With that, I would lead on, or in fact, hand over to our next speaker, Dr. Pitkowitz. He's a partner in the law firm Graf Pitkowitz. He's head of the dispute resolution function there. He's a very knowledgeable international arbitrator, as well as advisor on arbitration. With he's given me a number of acronyms that I will not pronounce now because it will be probably too long, but rather would like to hear from you directly, and I hand over to you. Thank you.
Thank you very much. It's a great pleasure and honor for me to be here, and thank you very much for the invitation to speak in front of you. I was actually reminded this morning about the significance of disputes stemming from the energy market liberalization when I received a call from my wife who informed me that the power had gone out in our house and she couldn't leave it. The garage door wouldn't open, the gate wouldn't open, and she said, "It's you because you switched providers." And and actually there was a total power failure in part of Vienna, and I managed to give her some advice on some remote opening, but it shows the dependence on energy, and it also shows that sometimes you need teeth. I was already preparing to file an action, but there's no need to do that. So as we just learned really from Ms. Rozeta Karova, the energy community has not fully developed its law enforcement system. The Ministerial Council may declare that a breach is made, provided it reaches the required majority, but that's about it. So it's like a lion without teeth. It can roar, but it cannot bite. Now, my task here is to discuss with you what can be done to give this lion teeth. And in the 15 minutes or 25 minutes or 30 minutes, no, I'll try to make it short, in the time given to me, I would like to discuss two concepts. One is a regional court. That is already the title of my presentation. And the second is a court of arbitration. Now, before going into that, why is there a need for a better law enforcement? I think to give an example which was taken from the Energy Community's website, if Macedonia, for example, enacts a law under which it opens its energy market only in 2020 and not as it has committed and agreed in 2015. So what can an investor do who has invested in Macedonia, waiting for the market opening and has already and has as a result potentially suffered a loss? Now, there is a report by the High-Level Reflection Group of the Energy Community of May 2014, which already mentions in very, very clear words that it is fundamental for investors within the energy community to have a system, and I'm quoting here, enabling vigorous and independent enforcement in countries which may not provide for credible recourse path for private and non-incumbent investors to pursue in case of breach on contracts. Now, why can't investors go to the national courts? Because that would be the obvious and clear issue. Why not? Now, I think in theory they can. And there are, however, a few obstacles and problems. One is what Rozeta already addressed, that is the question of the direct application of the Energy Community Treaty. Now here there is some debate about that, and I think if we use some analogy to the European Union treaty, then we can, on the basis of Article 6, we can probably say there could be a case made, but will the regional courts accept that? And what if they don't accept it? Is there any body you can go to appeal? There is not. Now, of course, there are other problems with national courts, and that is why they cannot provide an investor, and I'm speaking here mainly from an investor's perspective, why they cannot provide an investor the level of confidence it expects. Now, one reason which may be known to many of you is corruption, that the court system, there is an agency actually seated in Austria, Transparency International, and they publish regularly a corruption index, and they have an index for corruption in the judicial system, which ranks corruption on a level from 1 to 5. 1 is absolutely not corrupt, and 5 is absolutely corrupt. And they have, if you look at that, to give you some example, Switzerland, for example, has 2.2, which is one of the best. I think there's only 1 or 2 countries below 2. Austria is not listed in that ranking, so I cannot give you the figures, which may be good. The US have 3.3, which is already relatively high. But if you look to Southeast Asia, Bosnia and Herzegovina have 3.8, Montenegro 3.9, Albania, Kosovo, Serbia 4.3, and Bulgaria 4.4, and Ukraine tops it with 4.5. So I think that is definitely a problem with many investors when they are faced, when they have to bring their claim in front of a national court. Now, what are the alternatives? And I'm now going straight into one alternative, which I'm going to debate with you. That's a court of justice. And this is also mentioned in the proposal 4.6, which I already mentioned on the report by the high-level reflection group of the energy community of May 2014, which explicitly requests that the dispute settlement procedure should be gradually replaced by a court of justice based on the EU model as applied in the European Economic Area, in brackets EFTA court. Before becoming a permanent institution, the court could convene on an ad hoc basis. The court should also be accessible directly by individuals and companies, end of quote. Now, the creation of a court of justice would have the result that the decisions on legal issues would be decided by a court, by a body consisting of professional judges, and that is a big difference to the present system. The Ministerial Council, which presently decides, is not necessarily comprised of legal experts and can not necessarily be considered neutral. But even more important, a court can render an enforceable decision and grant protection for individuals and companies, which the Ministerial Council clearly cannot. The court would need to be established, of course, by a separate agreement. It needs to be a contract amendment and, of course, consent of all the contracting parties. And let me just share a few thoughts and ideas about how that court should be looking like, or could possibly be looking like, which I have developed now also in discussing this issue with the Secretariat of the energy community. Now, I think in the initial phase, it could be a body giving advisory opinions. This would be a very useful tool of assistance to national courts, particularly in the interpretation of law and in the interpretation of the Energy Community Treaty and the national obligations. That could be very helpful. And particularly if an investor would have the right to recourse to court to get an advisory opinion. Those opinions would be binding on the national courts and would be in a way different from the system now of the European Court of Justice, because as I mentioned before, it could be directly accessed by individuals. And the jurisdiction would in the first phase be limited to the interpretation of the Energy Community Treaty. So it would be a limited jurisdiction. In the second phase, that court, if that develops, could really replace and should replace the present dispute resolution mechanism. And if it's modeled after the EFTA court, it would indeed guarantee the subjective rights of the investors and could be directly, in specific cases, called upon by investors who have suffered damages. Now, how would that court be composed and how would the judges be elected? I think here we have a very good model already in the Treaty on Functioning of the European Union, which provides for member states to nominate candidates and a panel, an expert panel, often composed of retired judges, which is a part of the community then, who would be then interviewing the candidates and selecting them. Now, the court procedures, I think that should follow general models, and it's not something, it's a more technical issue I don't want to bore you with. I think there should be a need for hearings to be public and transparent. I think there should be a right for third parties also to be heard in the proceedings, to file an amicus curiae or another way, a submission to be heard, but not being necessarily be a party. The decisions should be final and with very, very limited exceptions. Now, that's the court model, and I want to, before I close, just give you an alternative, because I mean lawyers always have alternatives, and as a lawyer you always need to present or think what's the option, what's the other option, and the other option is a court of arbitration. And a court of arbitration here more precisely is an ISDS. It's an investor-state dispute settlement. This is a model which is very common, which is used throughout the world. Actually, there are more than or almost 3,000 bilateral investment treaties now, which are based agreements between states which follow that model. The NAFTA has it, and the TTIP debates it now with a lot of public negative opinion, which is in my view misplaced, but that is not the topic for today's discussion. The model of the advantage of an arbitral of a court of arbitration is that it doesn't require any financing in the first place. It has an enforceability guarantee of decisions, because under the New York Convention of 1958 and the European Convention of 1961, many the decisions of an arbitral tribunal are worldwide enforceable. And it is a system which we also know from another energy-related treaty, the Energy Charter Treaty. In the Energy Charter Treaty, that has a very complex model of dispute resolution clauses, but apart from diplomacy and a adjudication process in case of transit disputes, it elects arbitration both in investor state and also in interstate dispute, and that has been actually quite successful. There have been 64 cases filed so far. Many of you probably have heard of the Yukos and the Vattenfall case, which were filed under the Energy Charter Treaty. Now, with that, I think I've exhausted the time given to me. And Andreas has not stood up yet and walked around, so I would leave it to our discussion to debate. I think there's no question the lion needs teeth, but how shiny and figured these teeth should be, whether these should be court teeth or arbitration teeth. Thank you very much.
Yeah, thank you. Again, very interesting topic, very difficult to deal with in just a handful of minutes, especially if you want to go through the respective advantages and disadvantages of the different models. I think unless there's an immediate question from the group, I would have one. And perhaps just out of experience on other cases, I think one of the particular advantages of the court system vis-à-vis the arbitration model is clearly that when you look at situations where we in the energy context have or are currently thinking about investor-state arbitration under a bilateral investment treaty or the Energy Charter Treaty, you're obviously very limited to the point of the limited heads that you can bring a claim under, notably legitimate expectation, expropriation, and so on. I think the key attraction is it not for a court system or for something that goes more towards that direction is clearly that what investors very often want is the possibility to actually do something in the country. Very often investor-state arbitration jurisdiction is a bit of a nuclear option. You do that when you exit the country. And clearly, rather you want to stay and you want to go about your business, but you want to ensure that it's done in accordance with the principles of the Energy Charter Treaty. So, I suppose to both of you, the question isn't that what we are sort of probably really looking for in terms of ensuring a proper implementation of the acquis?
I think that's a very relevant question. In most investor-state dispute resolution system, there is a pre-phase, a cooling period provided for negotiations and discussions, and also in most investor-state dispute systems do not exclude national courts. So national courts could be an alternative remedy, but it's quite right that when you have the government as your opponent, that it may not be easy for you to have further investments in that country. I've had in my practical experience other cases. It is definitely a threat against the government, and very often these cases, and it's as you mentioned, Andreas, it is a nuclear weapon because it's taken very serious by governments, and quite often these cases also lead to a out-of-court solution, which otherwise couldn't have been achieved.
Yeah, so maybe just very shortly for the what would be the advantage of a court over arbitration? I mean, the Energy Community Treaty as such is modeled upon the EU treaty. Basically, it's export of the EU acquis, so it's very similar to the EEA agreement. And the court has already said, also the European Court has said that even though it's a sectoral, it was in the area of aviation, even though it can be a sectoral integration, it can be a very deep one. And in fact, a court modeled on the EFTA court would be maybe more appropriate to address also the compliance of with the energy acquis and so on, besides the investor-state disputes.
Do we have some more questions from the floor? Otherwise, I probably would have one more, if that's okay. And then because we were a bit pressed for time, we then move on. Is that okay, Dirk? Yeah, okay, good. You had a very interesting slide a little bit earlier on, which basically talked about the amount of proceedings that have been settled. And it also said at the top why the system doesn't work. Now, just playing devil's advocate for a moment, because it sort of leads on to the question, what system do we actually want? Do we want to have a court? Do we want to have some arbitral tribunal, something similar? How would you judge the relative success of those cases that have actually sort of not reached second stage, if you like? So, because one could obviously argue that since you've got a system in place with investor-state arbitration under a BIT and the Energy Charter Treaty, isn't that actually, a suitable complementary political mechanism that you don't necessarily have underneath other mechanisms? Or are we actually missing something? And it seems we're missing something, but what is it exactly that we're missing?
Yes, indeed. I mean, I wanted to praise also the achievements so far, but as I said, they are limited in a sense, not that much in number if you compare the number of closed proceedings in comparison to what we have still open, but they are mostly related to non-transposition cases, so where the breach has been obvious and where the deadlines are expiring. But we may talk whether it was closed on time, how many years the case has been open, how long the negotiations between the Secretariat and the countries have been going on, and so on. When it comes to implementation, and then also the question is why the Secretariat did not go to the second phase. Why did it push on closing the case, even if it was delayed? Because obviously going to the Ministerial Council does not mean that the solution would be solved. I mean, we like to quote also the case against Bosnia that we had. I don't think I referred to that one before, but it's a case that the Secretariat opened for lack of a legal framework in gas in place in Bosnia. We went to the Ministerial Council. That was, in fact, the very first case with which was an obvious breach. It was the advisory opinion was very positive on the assessment of the Secretariat. The Ministerial Council first year said there is a breach of the treaty. Fine, good enough. We wait another year to see if the breach will be repaired. The second year, the Ministerial Council said there is a serious and persistent breach. And that's it. Now we are waiting another year to see whether there will be sanctions or not. So maybe when we insist on closing the cases before and achieving compliance before, it does not mean that it's all perfect. Simply sometimes the breach is more simple, so the country also agrees to close it before, but it's not always the optimal solution.
Well, I'm certainly converted. I thank you very much for your presentations and for the additional input. I think it's fair to say it's certainly something where there is an identified gap and something needs to be done. I hope we, us, can report more about this next year. I hope there are some more further steps in this firming up, because it's, I think, a very important topic, and it's clearly very important to investors and potentially music to the ears of investors, but also a very considerable way in which member states and contracting parties of the Energy Charter, Energy Community Treaty, I'm sorry, lapsus linguae, can actually resolve their disputes in an efficient and perhaps slightly more amicable manner than an investor-state arbitration. So thank you very much again, and over to the next session. Thank you.